Well, Sam, thank you so much for joining us today on the SALTovation podcast. We really appreciate your time, and we're so happy to have you kind of to
Thank you for
converse
having
with.
me.
So, as we usually like to start, could you tell us how you first got into state and local tax and then what made you decide to stick with it?
Sure. I think, like probably most people, I didn't envision that I was going to go into state and local tax. I think you'd have to be kind of a weird duck to maybe envision this as a kid, but but no, I was an English major and a Spanish major in undergrad at University of Texas. I always knew I wanted to go to law school, so I went to University of Illinois with the goal of coming and working in Chicago. But I honestly went into law school thinking I was going to do family law. I always had like a real like passion for family law and litigating divorces, and I handled a bit of that in an internship in undergrad, and saw, you know what, I don't know if I want this. I don't know if I want the personal, like it's so personal. It's, it's these people's livelihoods, and it's a lot of emotions. And so when I was in law school, I had the opportunity to clerk at HMB, which is my firm now, acquired by Kilpatrick this past March. So if I say HMB, I mean my current firm. but uh, but yeah, I had the opportunity to clerk there and work with our salt group, and some of the really kind of the best minds in salt. Fred Marcus, Jordan, Marilyn, Dave. You know all these guys. And yeah, I started to think, okay, I never really thought I wanted to do tax. That wasn't what I envisioned originally, but it's a fun area of tax. I mean, you hear this a million times, but you get to play with case law and the Constitution, the Commerce Clause, Due Process Clause, all these things that really were these sort of like esoteric concepts in law school. But I've always been kind of a numbers person. I always really liked math. Excel does not scare me. I like doing the equations. But so I started here, my now firm, as a clerk, and when I graduated, I went to Deloitte Tax and did really income tax compliance for a couple years. A little bit of sales tax, but mostly income tax compliance, which is a fancy way of saying I did a lot of tax returns.
Yeah.
I did busy season, and I really got to understand like partnerships and K1s, and I don't know if I understood all of it for my first year or so, but you do a couple busy seasons and you get to kind of understand how the mechanics of a return works. And did that for a couple years, and I enjoyed it, and I'm glad I had that opportunity to kind of see the other side of it. Like I talk about this all the time, that like it's a life cycle tax. Like first it's the drafting of the returns, then it's the audit. You get the notices. Can you resolve them at that stage? You go through the audit process. You get an assessment you don't like. So I got to see the beginning of that life cycle, that tax life cycle at Deloitte. And now I get to do the next part, which is you get the assessment and you don't like it and you want to challenge it, you want to litigate it. That's what we do now. You can do some of that and in Big Four accounting or in any accounting firm, right? You can go to, in Illinois, we have the informal conference board, which is like a continuation of the audit. And you can do that as a, whether you're barred or not. But you reach a point in the accounting firm where you can't take it any further, and that's where we get involved, and it is a lot more fun. I would rather be coming up with fun ideas and drafting briefs than drafting tax returns. So I was very, very happy for the opportunity to come back, and then I've been at the firm in our SALT group for almost 10 years.
So how did that pivot back the opportunity, if you're at the Big Four, Big Eight, or whatever the heck it was when you were there, to go back into the law? How did that fall into your lap?
Yeah, I kept up with these guys. So I really did want to have the opportunity to come back. And the group has always been really good about right sizing. We were never gonna hire someone if we didn't have enough to kind of keep them busy. And so, when I left the firm, we didn't have the need for another associate. We just hired, I don't know if you know Chris Lutz, but they just hired Chris Lutz when I was a clerk. And so, yeah, they just hired. They didn't have a need, but just keeping in touch and making them aware that if there is that need, I would love to be, the person to fill that role, and then I could come back.
And
So
what
yeah,
a
it took a
great
couple
thing
years.
to marry that, the compliance with, because that's kind of big four, big whatever they were. And then I did a lot of returns, but I'm like, I want to do the advocacy, but I do controversy, but I don't go to court. So one thing I did feel like I missed out on was the ability to go to court, because you can shake the tree a little harder when you're like, we're going to sue you. So I have to have alignments with firms like yourselves so that we can take it forward and make that threat viable and not just like pretend like we're trying to settle. Normally I've been able to settle most audits with my legal writing and my advocacy in writing, but sometimes we can't. Sometimes we do have to threaten, and then we have to take it that next step. So it's really interesting that panned out. And I think it's so good for you to see, like, to me, a return is sort of almost like it's a draft, right? Because you're doing the best you can to put your facts and circumstances into the laws and into the forms. I mean, it really is never 100% accurate, as best as we do, because there's so many different positions that businesses take that allow for a beg to differ about a position being taken from the compliance perspective versus what the law was. And that's why you have an audit, because people beg to disagree. And sometimes the
Yeah,
departments take two extreme positions in their own interpretations of the law for their benefit. And that's where we sit in the middle of that. No, it's overreaching, right? We don't think that you don't sue on anything if we agree with the assessment, right? It's only when they want more money.
I agree. I mean, and getting to see kind of maybe the way things should be done and the way that things are done are two separate realities. But the memos to file that you draft with returns, so you understand your filing position. So if you have an audit in a few years, you understand why you did what you did, but maybe you don't want to put that. Those sort of understandings of how the process works was helpful. I'm glad I had the opportunity. And to your point, you could definitely get a ton done at the audit level or ICB, or we have here Board of Appeals. Those are all places that accountants or lawyers at accounting firms can go. But yeah, you reach a certain point where you don't have the same threat if they know you've got to kind of bring in somebody else.
That's interesting. You were able to go in though, and you're not even an undergraduate CPA, because Jordan's a CPA and an attorney, as am I. So it'd be
Yep.
like going into accounting without the CPA understanding financial accounting. That's tough. Like you said, you have to like numbers, because there is that brain of like understanding numbers and understanding law. And a lot of number of people don't understand law, but they understand numbers. And then the lawyers don't understand the numbers. So there's just this mix I think Jordan is a special person in that regard, that he gets all that, as Meredith does
Yeah.
with the Masters of Tax and her undergrad in accounting. Yeah.
Yeah, exactly. I think the only two folks in our group historically that ever had both were Fred and Jordan, who had both the CPA and the JD. But yeah, Maryland had an LLM.
Okay.
But but you're right. I mean, coming into an accounting firm without a tax background was challenging. But that's the way that at least Deloitte did things, and I think they still do. Like half of their class, their tax consultant class, was accountants, and half were lawyers. And you're starting at the same time. You're
Hmm.
getting the same sort of training. And yeah, the accountants are at a disadvantage because they don't really know how to read statutes and regulations.
Yep.
We were at a disadvantage because we didn't know accounting concepts or how to use Excel or really any of the basic things that you would have learned in undergrad. So it was, yeah, it's a unique process. I think
Yeah.
it works for them though to have
Well,
those two types
when
of.
because I'm 30 years practicing, so when I started, they didn't hire lawyers, and then I was one of the few, and then all of a sudden they're like, we should hire more lawyers because we have all this consulting work, so we need that advocacy, that statutory reading, and ability to understand the innuendos in the law, and so there became and a lot of CPAs felt very unseated because they're teaching the lawyers how to do the tax returns. So there was a lot of like not good juju, but that's much been resolved many years later. And then they figured out how to manage that, right? They want all those brains, left and right brain thinkers, to manage the compliance. Yeah. All right.
And it
Interesting.
takes a busy season or so to understand what you're doing and
Right.
to get it under your belt. I'm not saying I was in the same place as someone who has a CPA, but
Yeah, but you don't
you
do
start
tax
to.
returns in school either. I mean, you come in and you
Yeah,
learn, even in LLM, right, or a master's of tax. You're not doing tax compliance per se, not to the degree to which you do in a busy season. So it is a
mhm.
learning process for sure.
Well, yeah, and I love Sam kind of because what we talk about and what we kind of have always kind of brought full circle and is part of the reason how we have guests, right? Is that relationship component of it and how you maintain that relationship, you kept up with the people that you worked with and when that opportunity arose, you had someone to look to or they knew who to call and just like keeping up those lines of communication and especially with state and local tax, you can't know it all everywhere, you know, because it's more than one code, right? And so I love that that's what brought you back is just keeping up with that relationship because that's something that we love and is kind of the crux of this podcast realistically.
Yeah, because all the people that make up this, what we go to IPT to do and the Institute of Professional Taxation, just that network is huge. And when you were at Big Four, as was I, when I left, I thought, oh my gosh, I don't have a SALT deck in DC anymore. But I had a SALT person in DC because I've been in different organizations. I know different people. I work with David Hughes on a whole issue in Chicago, Illinois, because of what is a signatory? Is DocuSign suffice for the 5-prong test with software? I mean, how do you
Yep.
know what the interpretation is of a law or the application of it without talking to people to see how it gets applied, right? Because you're looking at the
Yeah.
law and you go, I think, can I get away with this? This isn't literally a wet signature. Just silly things like that are important.
Yeah, no, absolutely. Being able to call a practitioner in another state and ask them, I mean, I did that with you, Judy, with Colorado to ask you what's going on with the locals. This is what I'm seeing. What are you seeing?
Yep.
It's so important to be able to do for our
At
practice.
least you feel like you're not going crazy. I mean, you are crazy, but you're not going crazy. It's just part of the process.
Well, and I think we'll come back to talking about kind of the perception of Colorado as an out of stater because or
I
we could
thought I
have
was
a whole
giving you a segue.
I know. But I want to talk through some of the kind of fun case stuff.
Mhm.
So do you have like some memorable cases that you'll never forget, either good or bad, best or worst, that you're open to sharing with us?
Yeah, I'll start with good. I think that's more fun. And I'll start with a win because there aren't that many wins in the scheme of things, at least within my career so far. Because we do ultimately we settle a lot because it's in the best interest of the taxpayer a lot of the times to settle. I mean, even some of the strongest cases. I remember I had one with Illinois. It was a business non-business income issue, and what was the factor? Is it the factor of the subsidiary or the parent? And we settled this for like I think it was 80 or 90 cents on the dollar, meaning we paid like 10%. It's hard to justify litigating a decision to the end when you're getting such a good settlement. And I'm not saying that's always the case, but the point is like the strongest ones often do settle. So, getting a win is fun. And Jordan and I just had a big win in Oregon. It's still sort of ongoing. So, we won on a motion for summary judgment on the main legal issue. So I won't talk about maybe the merits of that case, but I'll talk about I think why that case was fun. And it was fun because we got involved like halfway through the process. There are a couple lower courts in Oregon, and both part of the tax court. And another firm had handled that first case, that first step in the litigation process and lost. And so they came to us and said, look, we lost. We want to see if you can come up with another angle. Is there another theory here that we could pursue? And Jordan and I and the team, we came up with some creative ideas on this. Kind of it was a case where I think the judge, as well as probably the department, knows that the answer was egregious. I mean, it's an income tax case dealing with apportionment and what sort of apportionment rules are being applied to them. And it was just egregious what was ultimately being done. But you still have, the statute has to support you. The statute has to say what you need it to say. And I think we were able to raise some really creative arguments that got us over the finish line. And it's always fun to win. uh, and now at this point, we're just trying to figure out how much this is worth. Trying to figure out, what does this decision mean as far as dollars and cents goes. And that's the stage we're at now, which is, it's more fun to have those conversations when you won versus when you lost.
But then the other thing is, it depends. If you got a motions for summary judgment, then we really don't have a decision except that you got it dismissed. So then it's like, is it out there for posterity that other people can rely on it? Right. So that's something I always struggle with, especially when people settle. And that's one value of all of us knowing one another is you got to know what's going to happen, because a lot of things are closed door. And so people don't know what position to take if it's a similar situation without talking to one another and saying, well, we kind of know this is where we got, because the governments don't want some of that stuff out in the public forum.
Oh yeah, absolutely. I mean,
which is unfortunate for tax practitioners and taxpayers to want to have some certainty when they take a position. Yeah.
You're right. I mean, you are right, Judy. That it's the disadvantage of other taxpayers when you're following the case and you're letting them be the lead case, hoping that they're going to get the resolution you want, and then ultimately they settle.
Yeah.
Yeah, we have a case in Illinois where that just happened, where we were waiting and they just settled, and now we're trying to figure out, can we figure out what's in that settlement agreement? Because in most states there's a confidentiality clause for a settlement agreement.
Yep.
So technically, you're not really supposed to share the terms of the agreement. Although, you could probably talk more generally, like, how did you settle? Did you settle on a percentage basis? Did you settle on just a number, a merit basis? Was it based on some sort of change in law? Like, you can probably get to an answer that's helpful to your client without them telling you, we settled for 10% or we paid 100 grand or whatever the answer is. There's been a lot of that kind of back and forth with the city of Chicago too, with the settlements dealing with the transaction tax. You mentioned earlier, Judy, that you had like an Illinois 5-part test issue. Was Illinois applies the 5-part test for whether it's taxable software. But I mean, we dealt with that relentlessly with the city of Chicago, where one taxpayer, they cut a great deal, and then you're like, okay, just give us the same deal you just gave them. But there could be, in the city of Chicago, you had a change in leadership. So previously, tax council was really kind of willing to work with taxpayers and resolve issues in a way that kind of made sense, even though they knew their law was bad. And I guess to talk more specifically about this, the transaction tax, for some of you that aren't aware, applies to SaaS streaming services in the city of Chicago, and it's all based on the location of use. So you could be an out-of-state SaaS provider, but your customers are located in the city of Chicago. Or conversely, you're not a SaaS provider, you just use SaaS. So, you use something like Adobe in the city of Chicago. You've got employees working remotely there. You're subject to tax. And this got really complicated because the city never modified their ordinance to do this. They just put out a bulletin and ruling 12 that suggested those things were taxable. And so then, and tried to apply it retroactively. So there was just a constant fight as to, okay, how far can you go back? And, we had like these audits where they're trying to go back to 2008 or 2010. I mean, just way back, because the look back period was 6 years. So it became really, I did like it because I felt like I could always provide some sort of value to clients, whether it's shortening the look back period or whatever. But it's less of an issue now that that's been on the books for a while. But you still see taxpayers all the time who, like I said, may not be the licensor of the software or the licensee, and that's just not on their radar, especially if you're an out-of-state company and maybe you just have an employee working remotely in Chicago.
Right. You don't understand it at all. We have that issue with our cities and home rule cities in Colorado too, where they go back longer because nothing was ever filed. So there's no statute. So you don't have a position, and it's difficult to argue some of these cases in terms of the facts, because We just don't have compliance because it's too confusing to do. And it's
Yep.
de minimis until it's not.
Yeah, when a state doesn't modify their ordinance or their statute, but changes the way that they're doing things, I don't know if that's necessarily right. I mean, you could say you're clarifying the law, which is what they said,
Yes.
but to me that suggests that your statute never really enforced it in the first place.
Or
And
anticipated it. I mean, I think that's the whole problem is sales tax is so bloody old and nobody wants to update the statutes really. And they're redefining what is tangible personal property, right? I mean, really, I don't know. The whole thing's kind of crazy to me. Like that Amazon even could assert they didn't have Nexus when they were delivering in their own vehicles because it was a separate legal entity or that because they had warehouses, separate legal entity was always interesting to me that that was not Nexus creating, but it was questionable. So there's just a lot of things factually about how business operates that isn't well suited to the ordinance, especially with front door delivery now, compared to going somewhere and picking it up. It's Citus. It's easier to figure out. We don't have that anymore. And we didn't really have that anyway when you Sears shipped stuff. I mean, Sears said stuff. Sears was Amazon before Amazon was Amazon, really. So
I saw a documentary on that recently saying like how disappointing it is that Sears is, had the financial troubles because they were actually set up better than anyone to be able to do online shopping because they had the what was it called?
catalog.
Catalog. Sorry, I just
Black and white. I would read through it every Christmas. Make my little marks and get nothing that I wanted.
But you're right when it comes to, whether it's a state like Texas who have always taxed something like data processing or information services and trying to use those broad concepts to tax any sort of technology that's coming out now. It's a problem. I mean, I think it was Wisconsin. Their statute doesn't tax data storage. So kind of like Chicago or like a lot of these states, they just put out a ruling saying, oh yeah, we always kind of meant to tax data storage and got really aggressive with that over the last couple of years taxing for sales tax.
Well, especially like with Chicago and the personal property lease transaction tax in reference to SaaS, because those companies that are providing SaaS, they're providing a service. So how am I providing a service and paying tax on a personal property lease tax, right? From like a nomenclature perspective, it's just it's odd and kind of also goes back to where it's like, you can't just take words. We like to say that words matter and they do very much so, but in some of these cases, like not litigated cases, but like in some of these instances, right, the words, are tossed around and they're ambiguous and you can use them however you want.
And it's tough on business to comply with the rules because they don't get it. So, and then new products are coming out all the time and the way they're building them up doesn't always fit nicely into a tax box. So,
yeah, I mean, to your point, Meredith, the ordinance says non-possessory computer lease. What the heck is that? And how would I know that that is SaaS or cloud computing, but for guidance that wasn't published until 2015, 2016?
So then kind of in that, vein of unfun, right? What do you have a case that is, either kind of like a worst, kind of not a good one, probably wasn't a win, but may have been a little bit kind of still really burns you, think that like even the ruling is egregious and just like really like it puts you in a bad mood every time you think about it because it was just so bad. Like the ruling was just bad or unfair.
Yeah, so you're asking this from a different angle than I was initially thinking.
You can go back. You can go back.
No, I like that. And I'm gonna chew on that. But like my first instinct was, the not fun part of this can often be like the attorneys that you're working with in a state when you're litigating. So I'm not gonna name the state, but there is a state right now in the South that we're working with counsel who I'm pretty sure his whole strategy is to make this as expensive and cumbersome and time consuming as he possibly can for us so that we'll just give up this case. And it's super frustrating. If you have an assessment that's like $20 million, then sure, that's fine. You can make this expensive. But some of these assessments aren't that much, a few $100,000, and when they start putting you through the ringer, it can become really expensive and frustrating. I'm very frustrated for my client that we
Yeah.
can't get to a resolution on. In this case, to me, it's a really simple legal issue. You know, do we have the ability to deduct income or not? Pretty simple, honestly. And we're still working towards getting to a point where the judge can reach a legal decision on that. Yeah, it can be frustrating, and I will compare that to a state like Illinois, where we just don't have those problems. The attorneys for the Illinois Department, the AG, are really friendly. It's not contentious litigation. Of course, we don't always agree on what the legal answer is, but it doesn't feel like gotcha litigation, or this attorney has used words like sandbagging and disingenuous, and things that are just, I don't know. Usually these things don't get so contentious. And to where we started this conversation, that's part of why I like tax. It's usually not as emotional. We care a lot about our clients and getting the right decisions, but there's no place for name calling when it comes to litigation. So that's the one I think of most eminently, because we're working through this currently.
Right. So really the issue I'm hearing you say is just really not kindness with dealing with one another, giving each other the benefit of the doubt, making emotional accusations of character,
Mhm.
character,
Absolutely.
whatever you call it, character alienation or care. I don't know. But I actually feel like I've felt like the things have ratcheted up a little bit, where it's sort of like, that's not what the issue is. The issue is black and white. It's this issue or that issue. It's a number,
Yep.
it's a whatever. But why are you throwing this other stuff in here to mucky up the issue? It's an economic issue. Let's go. And then there's this other stuff that gets folded in, and you're like, what's happening here with name calling and all that? And that does make it a very unpleasant process. Like, there are lawyers out there that will just throw all kinds of things out there that just deflect the issue from the issue at hand, that are character related,
Absolutely.
I think. Yeah. And that does
Absolutely.
give you a bad feeling of like, we're both supposed to be advocates. We're both agree to disagree, but can we have a, calm and methodical discussion comparing the rules and not throw in some other stuff? Yeah, it's interesting. And that does muddy stuff like emotionally, because it is your career and you spend a lot of time doing it.
Yeah, it feels like they're trying to kind of drive up the price to see if we'll balk at that. But the price meaning the amount of time we have to spend litigating
Yep.
this case.
Yes.
But I think I have a good response to the other angle of your question, Meredith, which was, what's bugging me, like, legal decision wise. Recently, what states are doing with states that have separate reporting, they're separate reporting states, and they're trying to enforce combined reporting via transfer pricing. The Tractor Supply decision out of South Carolina. We could talk about that. I mean, I understand kind of where the court is coming from on this, but if a state statutorily allows for separate reporting, the department shouldn't be able to just backdoor their way into that via alternative apportionment. And alternative apportionment is honestly the example I always tell friends who aren't tax people, who aren't in SALT, and they assume that what I do is trying to cut corners for taxpayers or try to cheat the states of tax revenue. And I'm like, no, like, listen to this. A company like Tractor Supply can follow the statute on its face using separate reporting, but the state can say, we didn't get enough, we didn't think that you apportioned enough, it doesn't fairly reflect your tax base in the state, so we're going to apply combined reporting. And kind of say your operating margin isn't fair, without having to introduce their own operating margin, without having to really do any work. And the transfer pricing is becoming an issue in a lot of states. We've got one going in Indiana currently. Again, South Carolina, they had a law change there as well. I don't know if you're familiar with Silva, who is kind of like the brainchild behind the operating margin issue, but it's becoming a real hot issue. And not a lot of states have separate reporting anymore, but
Mm-hmm.
States can go back to some of these old years.
It is very disheartening, isn't that? Because I've had situations where I've had a taxing jurisdiction impute my costs of goods sold. Basically, I'm like,
Mhm.
how do you know what it is? We'll tell you what it is. This is what we are, and like reconstruing us as a retailer versus a service provider. Like, who are you to decide what we are? And yeah, some of that's very upsetting, actually. And of course, they have a big carrot and they have a big stick. So you're like, eeks, this is material. I mean, I had $1 million dispute with a landscaping company years ago. We settled it for like $4,000, I think it was $4,000 all in, but it took 3 years. 3 years. And it took actually besides just advocacy, it took going out to city councils and like doing other advocacy, just like word of mouth advocacy, sort of like, do you know what this city's doing? Because it was a city dispute. This is a little overreaching, don't you think? So really, it didn't even get handled through the courts. It actually got handled through other backdoor channels. So once again, how are people supposed to manage that? It's a secret. Yeah. Interesting.
Yeah, I mean, with this, there isn't really like a lead case so far in a lot of these states. So it's just sort of sitting there. And like in Indiana, for example, we were kind of asking around, like to our earlier conversation, asking around to some other Indiana practitioners to see what they're seeing with the same combined reporting transfer pricing issue. And it sounds like there aren't really many cases in Indiana because maybe the courts aren't so favorable, and you have to kind of move very quickly. If you've ever heard of a concept of a rocket docket, where the idea is in some states they want you to finish in like a year, and so you got to get the whole case done. And it sounds like Indiana sort of operates in that way. Well, how the heck am I supposed to develop a really complicated case where I need expert reports and I have to develop what the proper operating margin is in a year? It's not really feasible. So yeah, we were kind of hoping there'd be a lead case, but I'm not sure if there is one currently.
Interesting. So that once again, you're kind of on the cutting edge of trying to figure out something. And I think that is one misnomer, I think, in our space is a lot of people are like, well, you know this, you practice in this. I'm like, actually, I've never dealt with your exact issue because your business is unique. And therefore, there
Mhm.
isn't anything exactly like you or you wouldn't exist. The reason
Yep.
you're here and you have a market is because you're doing something a little bit better than somebody else that's similar but different. And so I think a lot of taxpayers misappreciate that because that's their market. Yeah. And you're like, I'm sorry, I am kind of guessing. It is the practice of law and yeah, tax. Like I said, a tax return is a draft to some degree.
Yep.
You hope it's pretty final and you hope you vetted the issues, but it's not always, it's just the best you can do based on all the circumstances at the time and how much you're going to spend getting down the rabbit hole of that issue. Yeah. Interesting.
Yeah, and to your point, working from the best information available, and that always makes me think about how like the city of Chicago never previously had any of their publications. Like so, in Illinois or any other state, most states you can request a general information letter
Mm-hmm.
or a public letter ruling request. The idea is you say, hey, we want guidance on this, and we'll either disclose ourselves and it'll be published and binding, or we won't disclose ourselves and it won't be binding. But the point is that the city of Chicago didn't have any of that stuff published. So, certain folks had access to it and certain folks didn't. And you're trying to determine whether you're getting the same fair treatment as everybody else, and none of it was. So, I mean, credit to their legal department, and which was spurred by Bloomberg suing them for it, but they published it all, and so now you have access to. And I still don't know if I believe that everything is on there, but I think that a lot more information is accessible
Well,
now
in Colorado, we thought about they have every once in a while the Department of Revenue says we don't want to do letter rollings anymore. We're going to charge for it. We don't have the resources. You don't give us the head count. We can't turn them around fast enough. We don't know that we want to be bound by it. We can't, so we're fighting as practitioners to say we've got to have that option available. You cannot take that away. No, everyone's
Oh yeah.
not going to use it, but they don't know how to build capacity for it as a resource
So they're
either.
so they are not offering you like either, whether it's a what I call a general
No,
information
they
letter.
do, but they every once in a while they bring up to us, we want to take those away. And we're like, no, you can't. But they're like, we can't staff to it. Right? Yeah. So over my 30 years of being in Colorado, we've absolutely had the department say we can't do them anymore. And then, yeah.